jumping around a little bit on the agenda, so we were on item 6A when we left off, and we're going to go ahead forward with item 6B before we go into, go back to item 4. Sarah, if you'd like to introduce our guest.
Yes, we have Olivia Minshew with the City of Wauchula here, and she's going to go over the details of the Chastain-Skillman proposal for the surveying work for the water sewer corridor, particular for a specific area of this particular project. So, Olivia?
Good morning. Good morning. You have a proposed letter of agreement from Chastain-Skillman to the IDA for professional survey work. This agreement would cover subsurface utility locates and a topographic survey. The survey area would be along the right-of-ways of North Florida Avenue, just north of Matheny Road, running north to the intersection of North Florida and REA, and then running east along REA all the way over to the intersection of REA and US 17 northbound. The purpose of this is to have the survey work done so that in the future we can then design the infrastructure that would need to be constructed to extend the City of Wauchula's water and wastewater utility services along those right-of-ways. And eventually that would mean an entire loop in that corridor for water and wastewater. So to provide for future development in that corridor. Proposal is for just over $19,355. Again, this agreement would be with the IDA. The city is just a key player, as it is our utilities that would be specifically involved.
Is doing that loop more important than extending the lines toward Bowling Green from the college?
That's this board's decision. I mean, this is a proposal that would be funded under the currently awarded utility corridor project, the phase 1. So it would be one of the pieces of the entire utility corridor. Right now, our water ends right around the new Preco building, and our water ends, as Mr. Lambert has stated before, right at Winn-Dixie on the other side. So it would provide a loop, and looping the systems like that provide for better water quality and water pressure.
Well, yeah, I know that, but, okay, this is a grant that we put in, right?
Well,
The
this
grant's already been awarded. This would just be an agreement that would be funded through the award already.
Oh, it's your grant you're talking about?
No, this was
No,
the
this-
original
Corridor.
water
The IDA
sewer corridor
already
that
has
we
this
received the
funds.
grant to administer. And I don't know that that was included in that first round of specifications for phase 1. Now, that is something that we can revisit for phase 2. If we receive the funding from the EDA, I'm assuming that it would need to come back before the board to fund and award that grant. So, you know, that might be something we can discuss, but it was not included in phase 1, I don't believe.
Okay, when you say not included, I'm trying to get a handle on, has this board already approved taking this to the EDA?
We already
We
did
already
that
have
into
that.
phase 1.
Okay.
This is awarded, this is money that we're spending that was awarded
already
in the
been
first
awarded.
year
Okay,
cycle.
well, that's my question. So my other question is, did we understand as a board that it was gonna be the loop and not straight ahead to Bowling Green or south to Zaffa?
I don't know.
Because to me, I was under the impression that it was gonna be used to tie Bowling Green and Zoffo in, or part of it, or get that way, not a loop, around the REA building.
At this point, the city cannot service water and sewer to any potential development from the old Preco building there at the corner of REA south. Any potential projects there, we cannot serve them at this point. We would have to extend our services. And the
Well,
best way to do that, because our existing utilities are already along Florida Avenue and northbound 17. So it would have to be those right-of-ways that we focus on at this point to extend.
I understand that, but I also understand that my impression was that when that money was approved, as part of the money to extend the water lines that we were talking about on 17, not down Florida Avenue into 17, so I'm wondering how it got changed, or we just weren't told, or maybe I forgot.
I think the intention of the original grant was to work with the municipalities in coming up with the best route that would maximize economic development, within the county. That US 17 corridor obviously is the bulk of the development.
Yes.
Now, your question of you saying that you were under the impression that it was to extend just from 17 north or south.
Yes, it was part of the money, we knew we had
It
to come back.
is. It is part of that money, but it was also the intentions that the IDA, being the conduit for this grant as the grant administrators, would work with the cities, and basically they would be the ones to decide, which best route would service their municipality. I don't think that we had ever come up and stated, we're strictly going to extend straight from 17 north and south.
Well, why didn't they apply for the grant? Because my understanding was that we were gonna go north or south. This is the first time I've heard about coming north on Florida Avenue and then going east to 17 for the city. I thought it was a grant for the city and the counties to work together to go north and south on 17. So,
And this
I don't know,
would be
maybe
the-
I'm the only one that's thinking that. Maybe everybody else
I
on
think-
this board says, no, it was for the city.
I think what Olivia was saying though is that in order to service from Preco south, they don't have the ability to do that right now. Doing this particular piece is going to enable them to do that, which essentially allows us to accomplish the goal. That's one piece of the puzzle. One particular section of US 17 will now be able to be serviced by doing this loop of service.
I'm not against doing it.
I'm
I'm
not
just
saying you
saying
are.
that, if you're told something, you ought to stick with it. Unless you bring it back and say, look, we've changed our mind. We want the city to run their line. We're gonna move this money from 17 over to Florida Avenue. That's what I'm saying, is that,
Well, we're not
my impression was it was for north and south. And now this is the first time that I can recall that you've changed it without letting us know.
Let me say this. The bulk of the corridor expansion for water and sewer that can be accomplished in the next couple of years is pretty much all going to be driven by the city of Wauchula. The county doesn't have any intention to get in the water and sewer business between Wauchula and Zalta. That area will be served by the city of Wauchula expanding its sewer and water capacity. In this instance, they have another area that they prefer to connect, which is the Florida Avenue down REA Road to the existing water and sewer loops, so that they can increase their capacity in that area that has a lot of growth. We're strictly a conduit, as Sarah said. We're relying on the city and their preferences at this point to tell us what the best placement for this money is. I don't know what else to offer you at this point.
I'm not sure that there was ever anything defined specifically in the original grant saying that it had to be only used traveling north and south on Highway 17. Again, we were going to always originally rely on the cities, as Bill said, to tell us best how to utilize this grant. And to answer your question of why didn't they just apply for the grant, that can be answered as, rather than each individual city putting in separate grant applications, similar to the incubator application, the IDA becoming the administrator of that grant, we were able to combine each city's needs into one application to be managed through one entity.
And that would have also increased a lot of the cost, having
It would have
everyone do their
separate.
own engineering studies.
Right,
and-
engineering, surveying.
I don't recall us getting into that much specificity on where the issues were gonna be addressed, but, we can certainly go back and look at that or consider that moving forward. But I think that, again, the county per se is not in the water sewer business, so, you know, I would like to rely on the cities to understand their infrastructure and know where their weaknesses are that need to be addressed. But if you have something different to proffer, we can discuss that.
No, I just think that there is more land north of Wauchula to be developed than there is from Florida Avenue School to 17. And if we keep diverting this money, it's never gonna get done.
Madam Chair, can I ask a question? Olivia, this is to make service available on the westbound side of 17
Yes.
in that area, correct?
Yes,
Because
all of
the-
the properties up front, Highway 17 southbound on the west side
West
would be
side.
serviced from Florida Avenue. because we don't
Right
have-
now, the utilities on 17 are on the east side of
Correct.
17.
So the
So
properties on the east
this
side are
is-
actually
this
served
is
from
US
17.
17.
The properties on the west side are served from Florida Avenue.
This is US 17 improvement. This is tying the Florida Avenue lines over to the west side of southbound 17 so that you can pick up the properties on the southbound. It's
Right,
exactly,
all the properties on the
it sounds
southbound
to me
just
like
happen
it's
to be
exactly
served
what the
from
grant.
Florida Avenue. We don't
was
have
doing.
a line along 17 southbound.
Okay.
So that the most logical is to extend the lines on Florida Avenue, which is where those properties would be served from. They are properties that do front Highway 17. The service simply comes from Florida Avenue.
Okay, you said that's what it was for?
That's what it's, I believe that's what the grant was for
Okay.
US 17 corridor. and
We'll
that's
go back
what-
and look.
All of those parcels actually
Okay.
run from Florida to 17.
Okay.
There's no break in between them. So whatever you service from Florida Avenue, that same piece of property touches 17 southbound.
The west property boundary of those properties would be fronting Florida Avenue.
And the east fronts
Right,
southbound 17.
Any other questions or discussion from board members? So the issue on the table is approval of the Chastain Skillman contract allocating $19,000 out of that initial.
It's 19,355.
Do we have a motion?
So moved.
And do we have a second?
Second.
Any further discussion from the board? Any public comment? Henry?
Was this RFP?
Henry, can you?
That's all I have. Was it RFP?
No, we adopted a contract that was already in existence for executing the grant award.
We piggybacked off of the county's surveyor, which is Chastain Stillman.
Piggyback.
I do, I love it.
I hate them.
Is this,
Henry,
Too much.
Henry,
Dealing's
if you
going
have
on piggyback.
questions, we'd like for you to come up. We welcome your input, discussion, but we do need you to come up to the podium and address your comments from the podium.
I'm just trying to understand it. I think some of these, you hire certain professional services contracts to do ongoing. You had a Kimley Horn going for a while there, a CSC, I think, or engineering. Is this a similar? I mean, I don't want to take up the time on this because it's not that important. That's why I just asked. If this was RFP'd, it wasn't RFP'd. It was
No.
piggybacked.
No, that is correct. We had, when we received the initial award, we had the discussion at that time of adopting an existing contract to piggyback to save expenses
Right.
overall in the
And-
entire.
And this same firm does other work for the city, and they're familiar, and their rates are in line with the market rate for this type of service, and everything is fine, right?
Correct.
Thanks.
Any other public comment? If not, we have a motion to approve the Chastain Skillman funding. All those in favor?
Aye.
Anyone opposed?
Aye.
Motion carries.
Thank you.
So we'll turn it over to Bill. Bill's gonna introduce bionitrogen inducement resolution.
This time I'd like Stephen Southwell to come up. Thank you, Stephen. I didn't see you coming down that side.
Vanessa, I have a conflict on this matter because my son works for bionitrogen.
Thank you. Can we get a form for Donald? Thank you. Go ahead, Steve.
Thank you. Good morning. Apologize again for being a little bit late. We had folks come from out of town, and I had told them that they needed to be here to start at 9, and y'all were ahead of us, so I apologize for that again. This morning we had a couple things. The agenda has a inducement resolution, which is an action item that we have this morning to discuss. But wanted to also just give you a little bit of an update and spend some time talking about where the project is going and how we see this unfolding as well, and so how we can structure things moving forward. The project, as you all know, has been in the works for quite a while here in Hardee County. During that time, the approach by bionitrogen was always to look at multiple sites, and I think that's been discussed at this board, that there's been the opportunity to build multiple plants throughout Louisiana and Florida. And since we had any substantive discussion at this board, most recently, I can't remember exactly when that was, they have begun working in earnest on a couple other sites, and those processes have really helped put together a structure and some things that can be beneficial here to move this site along. By no means are those sites mutually exclusive to the Hardee County site, but at the same time, the company is going to deploy capital at the most efficient and effective means to generate a rate of return for their shareholders. So that's the backdrop with which we come here. So a couple of the cogs that work on this project, at least we see moving forward, that have developed. Some of them we have talked about most recently, which was working in a way to convert the grant, some kind of a loan structure where we could help accelerate the project, and we still want to continue conversations about that. Another thing that they've discovered in some of the workings in other areas is some additional tools that we might be able to bring to the table from the state economic development organizations that they've learned about, and we'd like the county's help on doing those. The thing that we want to talk about the most substantively this morning, though, is issuing revenue bonds through the IDA through locally here. Have the bonds be issued here locally. The initial approach was to have them issued by the Florida Development Finance Corporation, FDFC, which is a process that started in summer of 2012, about the same time that bionitrogen first started talking publicly in Hardee County about their site. That process got delayed and lengthened through a lot of the workings with the FDFC and their structure and their sort of overhead, so to speak, from an administrative standpoint. And as they've moved in some of these other locations, they've discovered that it can be done a lot more efficiently through a local level. And I think from a financial standpoint, a lot more efficiently, financially a lot more efficiently from a time standpoint, and have a lot more direct interaction with the local governments as they work to try to do this. So I think it's an opportunity both for bionitrogen to do it, but also potentially for the county to have a little bit more insight on that process as well, because ultimately that's the driver of the project. If the bonds, if they can't get a package together that makes it work to get the bonds issued, ultimately the project can't get financed and constructed, which is what we all want to see, so they can start making fertilizer and putting people to work. Just the high level, and I'll let Donnie Cunningham's here with Jones Walker, and he's going to do the heavy lifting on talking about the bond structure. We have an inducement resolution, which is the first step in that process, that says we do want to go ahead and move forward with the IDA being the issuer of the bonds, and he'll work through that and explain how that process works. But from a high level standpoint, IDAs were created from a state statutory standpoint to be a conduit bond issuer. That was the primary motivation behind the state creating the structure to allow local, county, industrial development authorities so that you can take advantage of tax-free bond issuance. And so there's an interplay here between the state law, which governs the process locally that has to happen, and then the federal tax law that governs the type of bonds. And so there's two sets of rules that you have to comply with both of them, but they don't always use the same words to mean the same thing. So there sometimes becomes a little bit of interplay there. But essentially the county would be the issuer of the bonds. They're called conduit bond issuance because even though the county is the issuer, it's not the county's money. The money's coming from the market, and the county, they're really they're non-recourse as it relates to the county. But in order to comply with the tax-free municipal bond requirements, you have to have an agency, a government entity that actually, takes on the bail of the issuer to comply with that. And it's probably a good time to just go ahead and introduce Donnie and let him kind of get into that, unless there's any questions about the generalities first before we get into the bond project. But we can talk about that, answer questions, and then I'd like to talk to you for a little bit about how we want to move forward with all these pieces coming together and get this project going. But I'd like to kind of get to the specifics of the bond first, if that's okay with you all.
Yes,
Is
thank
that
you.
good? All right. Donnie, I'll let Donnie introduce himself. But he's with Jones Walker. He works out of a Baton Rouge office, but they have offices all over the Gulf Coast, and he works in a lot of areas. But you can introduce yourself more better than me.
Thank you. It's nice to be here. Donnie Cunningham, Jones Walker Law Firm. I did live in Florida several years ago in Tallahassee, Miami, and I've come back, and we are doing some bionitrogen projects in other counties, namely Hendry and Taylor County. So it's nice to be here. In a federal tax-exempt bond issue such as bionitrogen, we start with an issuer who passes an inducement resolution. It's a quasi-governmental body, which this Industrial Development Authority is qualified under the Florida statutes. This is exactly the type of projects that the statute and state law gives you the authority to finance on a conduit basis. It's not the credit of this board, nor the county, nor the state. It's purely the credit of bionitrogen to place those bonds, but they have to issue bond through a conduit quasi-governmental issuer to get the federal tax exemption. So there's a lot of rules in play between state law and federal law, and this is the first step to start a bond issue at this particular issuer. It's called an inducement resolution. If you pass it today, it will draw a line in the sand to where bionitrogen can start spending money from any source whatsoever, be it the $2 million loan, its own funding, a bank loan, whatever, and then reimburse when we close the bond issue in the next few months. So this is merely a starting point. There's an inducement resolution in front of you that describes the project in Hardee County.
Do you have the inducement resolution? Yes.
It describes the project on a particular tract of property in Hardee County. It authorizes what we call a TEFRA hearing under federal law, to where we put a notice in a local newspaper at least 14 days before the date of the hearing. Every citizen has a chance to come up and speak for or against the project. In this particular instance, it's actually under federal law, it's classified as a solid waste disposal facility, and it takes the agricultural waste and turns it into urea through a process. So you would authorize the board, Mr. Lambert, to move forward with that, hold a TEFRA hearing, and then it also has a form of an agreement that protects this authority from any liability and provides indemnification from the company in the event that anything were to arise from these actions. So basically, this starts the process. Under state law, the Board of County Commissioners has to put this bond issue on an agenda, properly noticed, and they also have to approve it. That usually happens after the TEFRA hearing. So once again, we're here today to talk about a whole package of moving forward and trying to get Hardee County in a position to get in the queue to get private activity volume cap, which once again comes from the state of Florida on an annual basis. They get so many dollars to issue these kind of bonds. We got a $300 million state of Florida private activity volume cap in December of last year to carry forward for the Hendry County Industrial Development Authority. We're in the process of doing the exact same thing in Taylor County through its industrial authority. And we're scheduled next week to go to the Board of County Commissioners, and then we'll take that package to Florida Division of Bond Finance and try to get allocation later on this year. We want to do the same thing in Hardee County. I know there's some history here, but it's kind of like a fresh start. It's kind of like a fresh issuer. You know the area, you know the project, you've heard this before. But we hope to start fresh and start today and use this as a great economic development tool for the county and this whole area. Happy to answer any questions, but basically this just starts the process today.
Thank you, Donnie. Do we have any questions or comments from board members?
Donnie, can you go back and maybe give a little more specificity on exactly what happens? We go through this process and then you close a bond issue. What does that mean in layman's terms?
When you get to a bond closing, there will be some documentation, and there will be a piece of paper called a revenue bond. It's purchased by a private placement purchaser. In this case, we're talking to Deutsche Bank from New York, who's talking about buying several of these bonds in Florida as well as Louisiana. If you have let's just say a $300 million in round terms municipal bond, it's the same as going to a bank and making a loan. You give that piece of paper to Deutsche Bank, they loan $300 million to the company. It's restricted though. It goes to a trustee bank, so the company can't just take $300 million and not do the project. There's all kind of checks and balances. So once that money's funded, then there would be a request for reimbursement. For example, engineering, upfront costs, like prepaying a loan. If you decide to make an economic development loan to the company from your funds, that would be part of the closing package. It would be reimbursed at closing. Then there would be construction draws, just like a conventional loan, as the project progresses, that have to be certified by an engineer and other parties to get to the trustee bank to actually draw money to pay the construction as it progresses up to finalization. So it's really just like closing another loan. The lender's gonna have a lot of say-so as to how that money goes out and what it's used for.
Have we, this is more of an administrative question, but the formal name of BioNitrogen was changed in December of 13, is that correct, Brian? So we really need to at some point have a formal name change on anything that we have pending with you. I mean, the company is no longer BioNitrogen, I can't remember what.
The parent company and the subsidiary that a TEFRA approval was issued to has changed, so you're correct.
So we need to address at some point exactly formally who the company is dealing with, and not just you, Ken, and Stephen need to address. We all need to address that issue.
And Donnie may be a good person to answer this, and I'll just phrase it. One is, there was a TEFRA approval that I think through time lapses, and what,
We can't hear you, I'm sorry.
sorry. I'll let Donnie address the legal part of this, but there was the legal subsidiary that the TEFRA, the $175 million TEFRA approval was issued to by this board. I believe through the passage of time has lapsed. What we have done with Jones Walker is set up separate legal entities for each plant. So there is a separate legal entity in Hendry County, in Taylor County, and here as well. There are Florida LLCs. And the Hendry County and Taylor County have gone through the same process that Donnie is bringing you all through for the bond issue. So it's the exact same process. This is the third time that Jones Walker will be replicating this in the state of Florida. So I think the process that we went through a while back, as Stephen mentioned with the FDFC, I believe through the passage of time, and was to a separate legal entity, but two, I believe is no longer valid. Does that answer your question, or if you have another?
Well, it does, but I think that it precipitates some other action in.
Well, if you notice, there's a couple of whereases in our resolution today that really rescinds, if you will, that TEFRA, because it was not the issuer that's going to issue the bonds plus the lapse of time. So we have to run a new TEFRA, which will be controlled by this board, not that statewide issuer. So all that's out the window.
Just to clarify, I think what I think you're concerned about, Bill, is that there was a name change of the legal entity that we first entered into the agreements with in Hardee County, which was Bionitrogen Plant FL1 LLC, which I may be confusing the order there. There was simply a name change done to clarify and help them keep track of, that was changed to Florida Plant Hardee.
And my point is that we probably need to have some formal recognition of anything that is ongoing, that there was a name change in the
Understood.
company. I don't know if it had any other,
But I guess what I wanted to clarify is that the name change it was not a changed entity. The entity is the same entity. The name simply changed. It would just be like me changing my name. It doesn't get me off the hook with Wauchula State Bank of any notes that I signed with them before. So any agreements we entered into from a contract standpoint are still valid and binding. Anything we do and going forward, we want to reflect the accurate name and AKA and now known as and stuff like that. But just the concern is that anything that we have done in the past would be undone or there would be any exposure there because of the name change. The name change does not undo anything that's been done or make anything that has been entered into no longer binding simply because of the change in name.
okay, are there any conditions related to the bond issue that relate to it being site specific?
Yes, because the TEFRA notice, once you approve a form, will have to have a specific site in Hardee County filled in with specificity. So if some citizen wants to drive by that highway, we would describe it like that, fronting on Highway 17 or whatever. So once you run a TEFRA, the property description has to be accurate in order to close the bond issue. Now, if the property were to switch for some reason, or the amount of the bond issue changed materially, like by 25% or something, then you could do a re-TEFRA. It's not a common thing, but it's not unheard of. The TEFRA has to be accurate as to the property description and the name of the entity, which your point is we're starting with this Bionitrogen subsidiary in this resolution, which is the correct name of the company that's going to own the plant in Hardee County.
Okay, and the site, we're going to move forward with the site, but if the site changes, then you can re-TEF on the site.
Correct.
Does it impact the bond issue?
No, as long as you do it before you close. It would just create some additional timing on the notice. You have to rerun the notice with the proper property, but no, it doesn't impact the bond issue.
How does this, what we're discussing and proffering today, affect what we already had in place, the agreement that we already had in place with Bionitrogen? Is this in lieu of the initial agreement, or what are the expectations on the initial agreement?
What is the initial agreement? Is a contract to do what?
The initial agreements with Bionitrogen?
Yeah.
We obtained a $1 million grant from the EDA, and then we coupled with it a second $1 million, and it is allocated for the construction of a rail spur, and it is site-specific to the site at Vandover.
Okay, well, that contract would still be legal and valid. If you notice in practically every contract in the United States, there's a provision that is binding on successors and assigns. A name change would pick that up to where that contract is still binding to the effect of law. But it's really, there's a new entity, so, you know, we would clean it up at some point. You could do a First Amendment or something like that, but really the successor entity assumes the rights of the original contract party, so still valid.
Mr. Evers?
If I might, Madam Chair, board members, I have a couple of comments I'd like to make. First, to Mr. Cunningham's point, my recommendation to you would be, if you recall, I think the last time Bionitrogen was before us, there was some sort of a proposal, but there wasn't any detail about reworking the $1 million that was allocated from this board, and I think it's $1 million from the EDA, if I'm not mistaken. I think that we left that meeting with the understanding that we're gonna be coming back to us with some sort of a proposal. I think there were a lot of comments on the board that said we're open-minded, we're not gonna tell you no, we just wanna know specifics. We haven't heard back on that. I'm kinda curious as to where that is and how this might play if you're gonna make the commitment to start this process on this bond issuance. Where are we on the 2 million as far as how that is gonna work? And obviously, $1 million of that would require going back to the EDA because they control that side of it. Secondly, this is a fairly new issue to me. I know, Steve, you guys met with Bill last week or weeks before that, perhaps, on this idea and this concept. I'm not bond counsel. Mr. Cunningham is presenting today. He's a contact, I suppose, through BioNitrogen. I have contacts that I've worked with in the past on bond issues that I'd probably like to consult with about this inducement resolution and get any suggestions as far as what might ought to be in it that isn't, or someone to look at it and tell me it looks great. So, those are my comments. They aren't really substantive in nature, I suppose. It's just that starting a very long and what can be complicated process, and typically the issuing authority has bond counsel. There are blanks in the resolution if you've noticed. As far as counsel, my recommendation to you would be that we hire bond counsel, someone that's looking out for our interests as we go through. Obviously, Mr. Cunningham, what he has told you, I believe, is also, not only true but legally correct about. Bill, your point, I don't think, was that you felt like BioNitrogen's prior agreement was unenforceable. It's just cleaning it up.
Yes.
It's a matter of just making the names all amendments to whatever documents exist so that the name changes match. So, with that being said, I would ask that you take it under advisement at least. I'm hesitant to ask that you adopt the resolution today. We just haven't had any time to really digest the whole situation and have counsel from our perspective look at it.
I would like to say this, and I have had a brief conversation with Stephen and with you, neither over 10 minutes long, but I think it's important maybe to recall to the board that when we did our operational audit, the Auditor General took the position that really the only reason that industrial development authorities exist are to finance and refinance projects defined in Chapter 159 under bond issues. And we took the position that we were not simply relegated to that one duty, but that we could also enter into other types of contracts to foster and promote economic development. We sought an Attorney General opinion who concurred with our position that we did have the prerogative to do more than just financing and refinancing projects. But the criteria for those projects was the essence of the audit criticisms that we received as an IDA. And my perspective on those audit criticisms is that the criteria for doing projects defined in 159 is a fairly arduous process. And I certainly want an ability, if we're going to go down a project defined process in 159, I want to make certain that we do it exactly right. And there is language in there that puts, it appears to me to put a burden on us to determine the wherewithal or capabilities of the client to retire the bond issue, to pay it. It additionally asks us to vet the processes that are used in this project. And all I want to make certain is because of these other criticisms that in many positions are still standing, because the Auditor General will be back here in July, I want to make certain that if we're going to do a 159 project, that we don't miss one aspect of it and do it improperly.
If I may elaborate on that, I think Mr. Cunningham's comments are right on. It's in this process, this particular process, it would be my understanding that it would be the lending bank, Deutsche Bank or whoever it is that actually does the financial vetting. They're the one, This thing does not constitute an obligation of this board. There's no obligation, as Mr. Southwell stated, to repay it. It's a non-recourse thing with respect to this board. It's not legally carried as an obligation of this board. You don't pay it back. You have no obligation to pay it back. You're putting your stamp of approval on it for basically income tax purposes, as I understand it, basically making it deductible, the interest earned on them, tax-free for the people who ultimately purchase the bonds. So I concur with all he said. I don't have the concern that it creates some sort of a liability, and I suspect the actual lending bank does all the financial vetting that has to be done. But, you know, it's a fairly complicated process to initiate and to start, and my preference would be to understand it wholly when we get started and have the benefit of counsel looking at it from our perspective that really knows what they're doing in a revenue bond issue. That's the only, I have no objection to doing it. I've always kind of personally liked the project. We can, you know, the jobs are important. I know the county commissioners one of the jobs. So, but I do have, it's just a short timing sort of thing. It's a very complicated process, and you know, it's hit right on us, and to start the process at very short notice is a little difficult on my end. To give it a stamp of approval and say, sure, Madam Chair, put your signature on the bottom of it. I haven't completely checked it out, and that's my disclaimer for the morning.
Well, I think that's wise counsel, and you know, I think that we're all very intrigued by the possibility that this resolution brings to the table to move forward. I did have a couple of questions though, going back to our original agreement on the funding, because there were some things brought up in the last meeting that I just want some clarification on. In the last meeting, when you talked about, Mr. Cornegay, when you talked about the issuance of these bonds, you discussed that they essentially could fund any part of the actual process, from raw material to the production of that material all the way to the end product. But there were many other items that could not be funded from the bond. And you know, that was the basis for our conversation at the last meeting as to how we could redistribute the $2 million that we had allocated between our board and the EDA. So has there been a resolution on how those items or those costs are going to be funded now, or is that still problematic for you? Because our initial agreement was to fund after or in conjunction with other funding and not ahead of. So I just want to make sure that, you know, I understand this is separate, but I just want to make sure that, you know, we're still moving in the right direction.
Sure, a couple of things, I guess, to update you since I last spoke, which I think Stephen spoke on behalf of Bio-Nitrogen between that meeting and now. The process we have is a very straightforward 4-pillar approach. There's the feedstock, the plant, the offtake, and the financing. Deutsche Bank, we have a term sheet from them to provide up to $300 million of financing for the Hendry County project and the Taylor County project through a tax-free bond issue. Their legal counsel is White & Case, one of the largest law firms in the U.S. Jones Walker is one of the most reputable firms in the United States on tax-free bond issues. Deutsche Bank has a vetting process which requires them on the project pays for it, but they do a feasibility study on the feedstock. They do a feasibility study with an independent consultant on the plant. They do a feasibility study on the market for the urea. All of this is contracted directly to them for their due diligence process, which they started back in January. They have the funds available to do up to 10 plants in the United States. We would like this to be another plant. That's why we're here. From what we transpired last time to now, the concept still sticks, which is it's federal law. Once the urea is produced, once you have a sellable product, the bond proceeds cannot be used for that. So when we discuss the rail is something that's used to transport the urea, not manufacture it. Therefore, the rail cannot be included in the bond. or a different way, the bond proceeds cannot be used for the rail. The bond proceeds can be used to buy the land, build the plant, but it cannot be used to transport the final goods out. So one of the concepts that we had approached to you is, in order to expedite this process, we would like to have the funds advanced. And as a businessman, I completely understand the difference in risks of financing $2 million next to a $200+ million project versus advancing it. We do have a $5 million loan earmarked for Taylor County. We have a $9.6 million tax credit that has been funded in Hendry County. So the process here, as Stephen indicated, there's two components. One is the bond, and the other is the inducements that we would like to discuss with the IDA management in compiling. And I put in that basket a process that we go to the Florida Department of Transportation for grants. We go to the Department of Economic Opportunity for tax incentives. All these programs are available statewide, and they've already been approved in Hendry County, and they're in process in Taylor. So that's what I mean, is there's, from what Stephen said, is that there's a package behind the bond, which is a part of that is these proposals. And in that is the $2 million grant that was awarded to us. I would like Stephen and Bionitrogen to work with the IDA management or the EDC to come up with a specific proposal to the board. And in that process also would include the process that we're going through on the site selection process. So the funds we're assuming are still earmarked for Bionitrogen. What we would like to do is to come back to you with a firm proposal subsequent to this meeting on how those funds would be best utilized with the site selection that we're undergoing right now.
One point comes to mind with me at this juncture. We don't have control of the EDA money. And if that grant, I suppose it can be amended by the EDA in a subsequent meeting. I don't think it needs to go through this process, but this board would not be able to control what the EDA determines with that money. We will have to go to them and petition them to make some alternative provision for it. But I don't believe they will advance. I believe they are strictly reimbursement. There may be some provision, I'm just not sure, but I'm almost certain it's going to be very difficult to get them to advance money.
And what I would, I guess, to state right now is that is part of this inducement package that Stephen can go through with you or whomever to come up with a proposal. So I'm not here to ask you all to do something that's outside of your scope of capabilities. We're just merely here to provide the inducement resolution on the bond, because the bond process, as Donnie can attest to, is a lengthy process. So whether it's the EDA money or the IDA money within that grant that was awarded, that is something that will have to be readdressed. And I'd rather Stephen make sure that it's addressed in the appropriate manner than me to stand here and ask you to agree to something that's outside of your scope.
So if we agreed to do the resolution, but we were not able to rework the initial approval of those two, the $1 million from us and the $1 million from the EDA, is that going to hinder the project from moving forward? Is that going to cause, issues with the bond issuance? Is that going to be part of that agreement?
I mean, technically, it won't impact the bond issuance. It'll impact the willingness of Bionitrogen to borrow $300 million to build a plant here if it's not an efficient use of that money. I mean, so the simple answer to your question is no, it won't impact the issuance of the bond. It won't technically create an issue that will not allow the bonds to be issued. What it will impact is the business decision of my client to figure out where they're going to borrow the money to build and undertake the obligations to repay and invest in things, and just have to look at the total package. And so practically, yes, it does have some impact. It does have impact on whether this project ultimately gets constructed here and when. But as far as if we try to decouple the issues and look at the technical aspects of the bond, it doesn't. And the inducement resolution, the importance of the inducement resolution and the timing of it, and it's just unfortunate that we meet at certain, we have to have notice for meetings and all those things, and so it's not like we can call up and say, hey, let's have a meeting Friday and have something done. So we're stuck with the schedules of meetings, and so we would have liked to have had maybe a little more time potentially to have addressed some of these issues if we had been able to. But the importance is it starts the clock for them on what's reimbursable with respect to the bond issuance. So they cannot spend money that they can ultimately get reimbursed from the bond issuance until they have this done. It's like, from a construction loan standpoint, the expenses that are allowed to be, included in your first draw, there has to be some tie to that financing. So this is essentially that tool that says, on May 13th, the inducement resolution was enacted by the authority, and that's when this bond issuance, this project starts from a financial and from an accounting standpoint. So that's really the timing issue on our end, is having this done. The issues that are raised about having special counsel are completely understandable. We would want the board to have special counsel. You do not have to designate special counsel for the inducement resolution. If there's a concern about special counsel having reviewed the resolution, any issues there, it's a resolution from the board. It is not an agreement that's being entered into. There is a memorandum of understanding, and I would like to point out one important aspect of that with respect to some comments that were made on it's page B1 of Exhibit B of the inducement resolution of paragraph 2, subject to the borrower providing the authority with sufficient evidence to enable the authority to make the findings set forth in section 159.29. So the onus is on Bionitrogen to give this board evidence to allow you all to move forward. So this is, before you commit to saying this bond is done, then there's things that have to happen, and I'm kind of speaking out of turn. Maybe Donnie can elaborate on that if that's the concern. But I wanted to drive home the point that the real issue on the inducement resolution from a technical aspect is starting that clock with respect to what money they can then recoup from the bond issuance and manage the cash flow aspect of moving the project along. Because as you know, there's significant. It costs a lot of money to get me to show up at meetings like this, so they want to be able to get repaid for that.
Well, this is really the first step with the board. The board would see this project several more times, including a bond resolution once the details are worked out. And I guess general Florida law would say that if the $2 million doesn't work for some reason in the next couple of months, you could always rescind this resolution by the same way you passed it. So we'd have to have a valid and binding resolution to close this bond issue ultimately anyway. So there's a lot of checks and balances here.